regard to the state's motion to reinstate, the court is going to grant the motion to reinstate, and I want to go a little bit at length addressing it. In reading, obviously, the Noor opinion came out, and it was very clear that I disagreed with it, said so, denied the motion initially because of my disagreement, but not without first checking to see if I was duty-bound to follow it as precedent. And now, based on the defendant's appeal, this Court of Appeals has made it very clear, yes, I was bound from the moment the opinion was filed, and I accept that. I even agree with the decision in State v. Chauvin that their opinions have precedential value immediately. And I want to explain why, because I did not believe so before. My concern is how the Court of Appeals got to that position. They stated in their analysis that the plain language of the rule says that precedential opinions take immediate effect. That implies that this court disregarded plain language in the rules, or at worst, was too lazy to look up the rules. Neither is the case. Upon reading the Noor opinion, realizing its application to this case, this court immediately turned to the rules to look for plain language as to when opinions that are marked as precedential have in fact that precedential effect. We found silence, not plain language. I think the Court of Appeals reaches too far by saying there's plain language in the rules. There is silence. There is not language prohibiting or saying that it is entered at judgment or that it takes effect immediately, but it is silence. And I think what the Court of Appeals has inferred from the silence is that opinions take immediate effect when filed. I accept that because of my second reason. Despite my disagreeing with them that the plain language is there, it is my belief and an analysis that courts have inherent judicial authority to say when their opinions have effect. If the Court of Appeals believes that they're precedential opinions, they get to decide when they're going to file it, how they're going to file it, whether it's an order opinion or more extensive. That is in the rules. There is plain language about that. But clearly every court has inherent judicial authority to decide when their opinions will be effective. Because the rules were silent, in this court's view, our next step is to look for case law. And we found Collins, which said it does not have precedential value until judgment is entered. The state has successfully argued to the Court of Appeals that that was dictum in Collins and did not establish the principle that the opinions take precedential effect immediately. And I accept that. That is their ruling. And based on that, I think the inherent judicial authority, there is that authority to make that decision and to say, when we file a precedential opinion, it has immediate effect. I accept that now as a rule of law promulgated by the Court of Appeals due to its inherent judicial authority to make such pronouncements. Because no pronouncement was made to such effect by any court that I was able to find before the Chauvin opinion was filed, that is why I said that the precedential value did not attach until judgment, because that's what Collins said. District courts, I think, are more at risk to start calling Supreme Court pronouncements dictum and refusing to follow it because of that. I am granting the motion because although these cases are factually different, that is Noor and the case before us, I don't think it's a factual difference that weighs in favor of denying the motion to reinstate because of the language of Noor. Noor is very clear. When intent is directed at a single person, this is a legal principle that they have established now as precedent, then third degree may apply. Single acts directed at a single person fall within the gambit of murder in the third degree. And as I said, that was part of their holding. It is not dictum. Accordingly, I am bound by that. I have to apply the rule. Even though they are factually different, I have to follow the rule that the Court of Appeals has put in place, specifically that murder in the third degree applies even if the person's intent and acts are directed at a single person. I disagree with the state that the defense has forfeited any other grounds, and so that's why I'm permitting the other grounds to be argued, but I did not find them availing here. First of all, the ex post facto, the statute has not changed. It has remained the same for years, was the same as it is today as it was on May 25th of 2020. And finally, discretion. It is an abuse of discretion standard, but discretion can be abused. And I think when my ruling, both in the fall and lately, in denying the motion to reinstate, was based on a legal principle alone, not on the facts of the case. It was the facts of the case that this appeared to be an act directed towards a single person, and on that legal principle of the single person rule, this court granted a motion to dismiss for probable cause, denied the motion to reinstate. But now that the Court of Appeals has said in a precedential opinion specifying the single person rule applies to third degree murder, I feel bound by that, and I feel it would be an abuse of discretion not to grant the motion. As a last comment, there are cases, in fact I have myself, I think it was trial before last on a criminal sexual conduct case. The state came in on the day of trial asking to add an assault in the first degree charge, and it came out of left field. There was really no notice that that was going to be important, and since it was an assault in a criminal sexual conduct case, we were talking about different intents, different foci on the acts that were committed. And I denied the motion to amend because I thought it did. It came out of left field, basically. And this case is different. This charge has not come out of left field. It was originally charged. I think the defense has been aware that the state will take every opportunity to try and add it back. The remedy is not to deny the motion to reinstate based on timeliness. It is to grant a motion for continuance if the defense can prove to me they are prejudiced by this ruling. So, murder in the third degree is reinstated as originally charged. In this case, this is not a decision as to the other three defendants who are set for trial on a later date, and we'll address that later. Mr. Nelson, anything? Are you ready to proceed?
I'm ready to proceed.
All right. No other requests?
No other requests.
All right. We'll then proceed.